Welcome to our second podcast in this series, Creating a Caregiver Toolbox. We appreciate Frank Melia, CMPS from Contour Mortgage, for giving us this wonderful opportunity to do this podcast in their beautiful studio. I am Paula Pagan, a licensed clinical social worker for Long Island Elder Care. I have worked in the field of social work for over 30 years, and my mission has always been to provide seamless services for my clients and their families. I take a very proactive approach to treatment, and I want my clients to educate themselves about the services that are available to them. We always want to prevent emergency driven planning, which can have a very bad outcome. We provide in person and telehealth mental health counseling to seniors and disabled in our office in Smithtown. We also provide mental health counseling to seniors in assisted living programs. In addition to the mental health services we provide, I am a CEU provider, which is a continuing education provider for social workers and case managers. We all go through challenging times, and we are all having difficulty coping after the pandemic. We need support and coping tools to move forward in our lives. We have help for you. We're here to help you. So today I want to introduce Kim Smith, Esquire, owner of Kim Smith Law Group, PLLC. I have known Kim for many years, and it's an honor to be associated with her from her firm located in Melville, New York. Kim and her team handle legal matters, and we want to educate you on estate planning, trust administration, Medicaid planning, and application and guardianship, and special needs areas. Their goal is to provide their clients with practical advice that they can use to decide in healthcare options available for themselves or their loved ones. So welcome, Kim, to our podcast today, and we will be discussing the importance of obtaining appropriate legal documents and what planning needs to be done in a timely manner. So I'm very happy and very excited about this podcast today, Kim. So please tell us a little bit about yourself, your background. You have an interesting career path that ultimately led you to where you are today.
Yes, and thank you so much for having me today, Paula. It is my first podcast, so I'm extremely excited. So I practice in the healthcare profession as a radiation therapist for many years, over 15 years, and that kind of led me to this path. When I went to law school, I initially thought I'd do medical malpractice defense work, but then I discovered elder law and estate planning. And it was kind of an extension of what I was doing for people in the hospital and the healthcare community. And that's all I've done since the day that I graduated school. I did law school at night while raising 3 young children and working full time.
Right.
So I am passionate about it. I love what I do. I love working with you. We've worked together for, I hate to admit it, but about 20 years.
Mm-hmm.
And I believe we have the same goals and that we really like to serve and are dedicated to our clients.
That's wonderful. Can you explain the importance of having legal documents? Why is it so important? Why are we discussing this today?
Right. So, pursuant to what your whole podcast series is about, we need these documents to help provide for crisis, to help provide for planning for our families and for individuals. And without these documents, you can find yourself in a very precarious situation.
So tell me a little bit about what is the power of attorney, why do we need it, and why should a POA be a durable one? So those are the 3 questions I have on that.
Sure. So I'm going to back up a little bit. So one of the most important documents for estate planning are directives, of which the power of attorney is one. Healthcare proxy is another, as well as the living will. So we'll start with the power of attorney. The power of attorney is an extremely effective document. It's a necessary document. It gives the individual that you appoint the authority to handle finances for you, change beneficiaries on accounts, file income tax returns, get insurance forms, create trusts. all the tools that you would need in a crisis situation if you lost capacity to do so. A durable power of attorney is a power of attorney that withstands your incapacity. So if it doesn't have the word durable in front of it, it really isn't good in the field that me and you practice in, because if it doesn't have the word durable, then it ends at your incapacity. And we really want a power of attorney that will continue and bring you through your incapacity. Very important to pick the appropriate person, because the power of attorney in the wrong hands can be a dangerous tool, because it does allow for gifting of assets and moving of money. So you really have to choose the right person that's appropriate to act. And you can choose two people to act at the same time and have to act together, or you can choose a single person and then another one successively. So you have a lot of different ways you can accomplish that.
Right. Now, let's say you don't have a durable power of attorney. What are the consequences if you become incapacitated?
So the consequences are for accounts and assets that you own individually. They're not going to be able to be moved or placed in a trust, or even paying out a required minimum distribution at retirement age. You wouldn't even be able to set that up, which can lead to huge penalties. So not having a power of attorney, you would actually, and if something needed to be done with one's assets that was incapacitated, you would have to go to court and do a guardianship proceeding, which is timely, costly, and it really puts the family through, a lot of stress. If you're appointed a guardian, you have to account to the court every year for every penny spent, for any assets collected. And if you're a family member, that can be very burdensome and very stressful. So really having a power of attorney in your toolbox is a great tool.
I agree with you. And I think it's very important for people to understand, if they don't have one, what the ramifications could be. So thank you for that.
And even if they do, they should look to make sure. There's a lot of statutory short form power of attorneys that were called the Blumberg forms, which are great forms. They're one page, and they're great forms to get insurance information or anything like that. But it doesn't provide you for lack of a better word, the tools again to do more extensive planning or crisis planning.
Okay. And explain the importance of the healthcare proxy, and who should we name as our healthcare proxy?
Great question. So to me, I guess with my healthcare background, that's one of the most important documents, because that appoints an individual to make medical decisions for you if you're not able to. So that document, unlike the power of attorney, becomes effective upon incapacitation. With the power of attorney, we usually sign them and make them effective when they're signed. You can make it springing upon incapacitation as well, but then you need a doctor to sign off. And a lot of times when it's related to assets, doctors don't want to sign off. They're afraid they're going to be held liable. With the power of attorney, it's the doctor determining that the individual can't give them the decisions they need regarding their health care. So they're usually the ones that will then say, do you have a health care, or say to the family, is there a health care proxy in place? The importance of this is there is a statute that provides an order of who can act for you medically if you don't have a health care proxy, but it's a broad level of individuals. So for instance, if as an adult, if you have adult children, they would be, if you had a spouse, that would be the person to act. But say your spouse predeceases you and you have 4 children or 3 children, the next class of individuals that can make medical decisions for you are your children. And what if they all don't agree? And there's no priority to whether it's the oldest that has priority or the last. They all have priority. So it's really important to have a healthcare proxy to appoint that individual.
Thank you. What authority does your healthcare agent have regarding your medical care?
So they have the authority just as you would. So they would have the authority to discharge you from a nursing home or from a hospital to a nursing home for rehab, perhaps. They could get prescriptions for you, okay, surgery for you, get your medical records, do anything that you would normally be able to do. We add to our healthcare proxy that it also enables them to hire someone like yourself, a geriatric care manager, to help assist them, with home care, maybe at home or items like that. And again, just like with the power of attorney, if you don't have a healthcare proxy and there's a disagreement on your healthcare needs, you would be in guardianship court. And another thing I'd like to mention is in a basic healthcare proxy, it does not allow for placement. Okay, so even if you have a healthcare proxy, if in the power of attorney we put that the agent can place the individual or as well, if you don't have that language somewhere, I've actually had guardianship solely for placement reasons where the family didn't agree on placement.
That's an excellent point. Thank you. Um, what is the importance of obtaining a living will? And sometimes people get confused between the living will and the healthcare proxy and all of that. What do you think?
So the living will kind of gives directions to the individual that you're appointing in your healthcare proxy as to what your end of life wishes would be if you weren't able to portray those yourself. So it would be, examples would be no feeding, no hydration, no life support if you were in a state of incapacity, no chance of recovery. So that document normally doesn't go to the hospital with you. That document is truly for your family to know that that is your end of life wishes, so that if that's posed to them by the medical team, they are not making the decision themselves, they're just translating your decision. And I recently had a woman that came in, it was the daughter of one of my clients. She came in after her mom passed. She was quite upset. She told me what had happened, and she told me, I'm having such a hard time living with myself to make the decision to take my mother off her life support and etc. And I looked at her and I said, you didn't make that decision. She looked at me confused and she says, what do you mean? I said, your mother made that decision. Me and your mother had that conversation. We signed the living will, and that document was giving your mother giving you instructions as to what her decision was if it came to that. And she thanked me and said that, she didn't realize that.
It must have been such a relief for her.
It was comforting to her.
Yes, definitely. And then also I want to ask you the difference between a will and a living will.
I know. Yeah, I dislike that they call it a living will because everyone comes in, I need a living will, and I'm looking at them, and usually they mean a last will and testament.
Yes.
So they're very different. The last will and testament is used to distribute assets upon your passing. A lot of people come in, they're like, I don't need a will. I have beneficiaries on items. Why do I need a will? I don't have great will. Well, a will can be a tool also. A lot of times when people come in, especially retirement age, actually any age these days, we put a clause in there that says if any of my beneficiaries are disabled at the time of my death and the time of them inheriting, then instead of the money going outright to them, it can go into a special needs trust, or in New York we call it supplemental needs trust, for their benefit. And what that does is it protects the assets if that person's in a nursing home at the time that they inherit. So I'll give you an example. We have a husband and wife, and husband's ill, and husband goes into a nursing home, and we use that great power of attorney to move all the assets from the husband to the wife, because we can in New York without a penalty. Topic for another day. Mm-hmm. And then the healthy spouse, what happens if the healthy spouse, they both have sweetheart wills, right? Most people have wills. Leave everything to my spouse, and if my spouse predeceases, then I leave everything to my children or whomever. So in that scenario, if all the assets are in the wife's name because the husband's in a skilled nursing facility, and now the wife suddenly passes, her will is going to give all the assets back to her husband. But in the will, if we direct that if anyone is disabled at the time of the person's passing, they go into a trust for them. Those assets, instead of going back to the husband that's in the nursing home, will go into a trust to be used for him and protected. And then when he passes, they ultimately will pass then to whoever, the kids or whoever the successor beneficiaries are going to be. There's other items about elective share, and there is some exposure of those assets for Medicaid, but that's a topic for another day. Right. And also, a will would have a minor's trust for any grandchildren that inherited. Appoints the executor, the trustees of those trusts. So a will is definitely an item to have in your estate plan because it can really protect assets, and it can handle tax things too.
Right. So another question I have for you is, how often should you, review your estate planning and update it?
Great question. So, really, any life changing events. So, a marriage, the birth of a child, the birth of grandchildren, retirement, illness, divorce. So, any big life changing events. If you don't have a huge life changing event for many years, maybe every 10 years, the laws change, as you know, so frequently. So, it's really important to stay on top of it and have a good plan put in place.
Okay. We hear so much about trusts. What is the difference between a revocable trust and an irrevocable trust?
Great question. And there's a lot of people out there that have revocable trusts that think their assets are protected, and they really aren't. So, living trust or trust created during your lifetime. So, when I was just discussing the will and the supplemental needs trust for the disabled beneficiary, that's a testamentary trust. That trust isn't created until the death of the individual, and if that trust in the will is needed. So, living trusts or trusts we create during our lifetimes, and there's a revocable and there's an irrevocable living trust. So, the revocable living trust, you would retitle, you would create it, you would retitle your assets in it, as you would with an irrevocable trust. And what the revocable trust does is both trusts avoid probate for the assets that it holds. Probate's the process of admitting a will to the court with the death certificate and a petition to get someone appointed to act on your estate, as in the last will and testament. With a trust, you're appointing the trustee during your lifetime, and that trustee or the successor trustee is going to continue to act during your incapacity or after your passing. So there's no need for court intervention. So a lot of people do revocable trusts to avoid probate. You want to avoid probate if you have properties in multiple states, if you have a disabled beneficiary and you don't want the court to appoint a guardian ad litem. There's many different reasons. But it's really important to note that a revocable trust does nothing to protect your assets for long-term care purposes or needs, because the person who creates it's also the person that's the trustee and manages it. So you're not giving up any interest in it. Therefore, every asset in that trust is exposed for your care. All right. The irrevocable trust, in contrast, you set it up, but you and or your spouse cannot be the trustee. You have to appoint a third party, such a child, a friend, a niece, a nephew, so you don't have control over that trust. So any asset you put in that trust, you're giving up the control of that asset, thus it's in there, it's going to be protected. So for purposes of long-term care in a skilled nursing facility, there's a 5-year look back. So if you put a house in the trust this month, 5 years, June of 2028, that house will be protected. So you retitle the asset much like you gain the asset. So when you purchase a house, it's by deed. So a new deed would be done, and the deed would be put into the trust. For community Medicaid, right now, home care Medicaid, their quote is no look back. They passed a law in October of 2020 for a 30-month look back, but they have not instituted that law yet. And the talk is it won't be at earliest till next year. One of the biggest assets that we'll put, or the asset I do most into an irrevocable trust, is the home, because you are giving up control over the assets put into the trust. But with the home, you have the right to live in the house. You still pay the taxes. You still pay the utilities. You can direct the sale of the house. You still get your STAR exemption. You still get your veterans exemption. So nothing really changes for you. When you put liquid assets into a trust, such as a brokerage account, you're only entitled to the income generated. You cannot touch the principal. So it can be prohibitive. There are back doors to get principal out, but it has to be done properly.
Exactly. Thank you so much. What you're sharing today is just so valuable for all of us and such a contribution to our Caregiver Toolbox. So I thank you very much for your time today. And this is our second podcast.
Yeah.
I'm very happy. And until we meet again.
And I'm honored to be here, and I thank you very much.
Thank you.